So the first slide I want to talk about is always the important one. You know, it's particularly when you're common law, right? When's your relationship over? It's always important to know when it's over. This was kind of an interesting case that I'll get to. So for the purpose of the Family Law Act, spouses may be separated despite continuing living in the same residence. And the court may consider as evidence of separation communication by one spouse to the other spouse of an intention to separate permanently being the word, and an action taken by a spouse that demonstrates that a spouse's intention is to separate permanently. Now, of course, you know there's two different types of spouses. There's the, I can't say it. Oh, see, I got to filter. There's the married people spouse, and then there's the common law spouse, right? The 2 years or more living shacked up together, or you can be a spouse also if you are shacked up not for 2 years, but you have a child together. You're still a spouse. So mostly the issue arises when you're talking about common law spouses, but it can be for married folks as well. So we're going to go to our new case of the year. It's called Barch and Barch, and this is Madam Justice Young. And the main principles we draw from the case law are that there needs to be a meeting of the minds on the intention to separate. Nah, it's not required, right? You can be one person saying, I'm done with you. We're out of here. I'm done, right? And if Vinu says, please don't go. It doesn't matter. I'm done. We're done. It's over, right? So there doesn't have to be a meeting of minds that both parties agree you're separated. We're done. Physical separation combined with one party's intention to live separate and apart is sufficient, but not always. We'll get to that. It's not enough for one party simply to form the subjective intention to separate. It's all in my head. There must be some objective evidence that the party wishing to separate communicated that intention to the other party and took action consistent with that intention. So I'm going to go through a case and then we'll know what's this case and we'll know a little bit more what that's about. Useful to compare pre- and post-separation behavior. Sexual involvement, or lack thereof, is not conclusive. Because you know, many spouses don't have sex anymore. So, you know, that can't be the thing that defines whether or not you're in a marriage-like relationship for some people. And some people actually, post-separation, they still have sex, even up to the date of trial. It's quite irritating. So there was to be no laughing, recall. So the objective evidence from the relevant time frame is more probative of the nature of the parties' relationship than viva voce evidence of the parties in the midst of an acrimonious and bitter proceedings. And why is that? Because you know, by the time you hit trial, people have very different stories about what happened in their lives. So at the time you separated, you might think it's this day, I'm done with a person. But when you get to trial, you're like, what advantage would I have to delay my separation? Let's see, our RSPs went up a lot. His RSPs went up a lot, and then, yeah. Anyway, he got some bonus from his work. Yeah. It's very important that you have something marking at the time of separation. You know, usually a U-Haul is a good idea. If you've got the U-Haul receipt, that's a good sign you're separated. Madam Justice Young cited a case called Kupar and Rowe, and it's a decision of Mr. Justice Harvey, who also is a long-time family law practitioner. So oftentimes the question is, can parties be separated even though they still live in the same house together, right? Because some people, for practical reasons, either there's kids or nobody can afford to live separately on their own, or nobody wants to give up the house. They still continue living together. It always helps if you have either have another suite or a separate bedroom. It helps to clarify that separated. So this question, though, before Mr. Justice Harvey was more, can you be in a marriage-like relationship while living under different roofs? You're still separated. You're living separately, but can you still be in a marriage-like relationship? Yes or no? Well, the answer's up there, sorry. Yes, you can. So some of the factors that Mr. Justice Harvey went through is there was a lack of changes to distinguish the relationship before moving into separate residence and after. Like basically, they didn't change their lifestyle. They still, I don't know what this means, like they still performed domestic services, cooking, cleaning, and laundry. I don't know if they went to each other's houses and they were like cooking for each other, or, you know, one person moved into a place without laundry, so I had to come back to the house and do laundry, maybe. They still had regular interactions between them. They went out for dinners, they went to events together, they portrayed themselves as a couple, they made gifts for each other, they took vacations together, and neither of them shacked up with anyone else. And I think in this one, they didn't actually put on their taxes anything different. So in this case, they continue to use the same bank account. They had joint bank accounts, joint things. So even though they lived under different roofs, the court in Coupar and Rowe, Mr. Justice Harvey, found that they were still in a marriage-like relationship. And usually you're getting this case because one person is trying to argue that they're not, right? So in Barch, this is why it's fun, because you generally have people who have very different dates of separation, and sometimes you have two. I can't decide. I think it was December 30th, it could have been May 8th, or maybe it was November 30th, or maybe it was the spring of 2014. So this is what the court has to sort out. Now, this isn't that big of a spread. There are some cases where the spread is like, I think I saw one case, it was like 11 years. Yeah, it was 11 years. She didn't win on that because, in fact, he had another relationship through much of that as well. Although that is not necessarily indicative that you're not still in a common law relationship with somebody else. You certainly can still be married and have, ongoing things, as you know. Not personally, I know you don't know, but, you've heard. You watched the Kardashians. So, December 30th, this is what happened. Ms. Barch, she saw the respondent, Mr. Barch, engaged in a public sexual act in a nightclub during a trip to Las Vegas. And clearly things don't stay in Las Vegas that happen in Las Vegas, because she came home and she was like, in her head, my marriage is over. But then she forgot to tell Mr. Barch that, and in fact, this is the thing, she didn't even say that until it was close to the trial. Oh, I think we separated in December of 2012. And Madam Justice Young says, being angry and keeping that anger bottled up for months or years does not communicate to the other party that the marriage is over. It only communicates to the other party that the marriage is unhappy. So, unless you say marriage is over, or somehow indicate marriage is over, you don't have to speak it, you have to show it, then the other party won't know it's over, and you'll have a hard time convincing a court that it's not over, that it's over. So, I'm not going to go into Mr. Barch's dates, because the court finds that May 8th was the date in which they separated. Because a couple things happened. The parties had owned a company together, and they basically took steps to set up their own companies, and Ms. Barch set up her own bank accounts. She also talked to a divorce lawyer, which isn't always a sign of separation. Sometimes, because we as divorce lawyers have obligations to try to make you reconcile. So, sometimes we're good at that. And so we might send you back to your loving relationship. But she ceased sharing a bedroom with Mr. Barch in early 2013, and she also vacated the home as much as possible. She went on work trips, and she wasn't around a lot more. And then the kicker was, Mr. Barch left for Vegas in May 2013 and got a lease in his own name. So, but, did they tell each other that we're done? No. They didn't vocalize it to each other. So the judge had to kind of basically look at these factors and said, well, what happened was Mr. Barch went down to do business. His business kind of tanked down in Vegas. So he came back to the family home, This is why he picked two other dates, in November 2013 and spring of 2014. Spring of 2014 was at the time where they both I think they sold the house, right? So that's kind of a sign. But anyway, he tried to say, no, I came back. So therefore, we didn't separate while I was away. Anyway, the judge was like, I ain't buying any of this. Basically, she found that the respondent was telling other people, Mr. Barch, in April and May, that he was unhappy in the marriage and he was going down to Vegas to start a new life. As I said, he only came back because he was unsuccessful in his business. And the wife interpreted his actions to mean that they were separated. So, the judge says, it is difficult to determine a date of separation with a couple who do not argue and do not communicate. There is no clear date when the parties said the marriage was over and agreed they wanted to separate. So the judge had to sift through all the evidence objectively and stand back and say, okay, are they separated or not, and when, right? Pick a day. I had a case where the judge picked it was actually a date of cohab, a date that nobody picked. And it kind of, well, screwed my client, I should say. Not screwed, anyway. Shoot, okay. I am really not good for public broadcasting. So this one is interesting because, of course, people on their tax returns often don't change things, and they leave married or they put separated, and then they say, well, you had married on it, so you must have not been separated, and people always blame their accountant. My accountant just did it, right? But some judges will be a little more sticky about, okay, if it's one of the factors they'll consider, right? So obviously if you put separated and there's other factors that show you're separated, they will indicate that you're separated. If you leave it married and you just don't ever change it, it doesn't automatically mean you're not separated. So in this case, as Mr. Justice McKenzie said, look, the fact that a party has stated married on her income tax return has little impact on the analysis. It doesn't undermine when the party's separated, because you look at all these other factors, and that would help you determine whether or not they're separated. So that is separation. That's a fun case in separation. But it's more and more important, as you know, for property purposes, is when you separate. And that's why people you can nickel and dime around days and weeks and months and stuff. And sometimes, I'll talk to clients who are like, well, actually, it's like, I need the truth. I need the truth. And sometimes people don't really know when they separate, right? Because sometimes it's a bit fluid, right? It's fair enough. Even people, when they shack up, also don't often know when they shack up. Because it's you're hanging out for a while, you sleep over a few times. And when is it you are officially there? Is it the toothbrush? Is it a pair of socks and underwear? Is it when your cat comes over? I don't know, So it's not always easy. As I said, U-Hauls are good indicators of these timelines. I believe in U-Hauls, and I do not have shares in U-Haul. The only thing I'm going to on property is just because there's a couple new cases, it's not really rocket science. You probably get this. You can restrain people from disposing of their assets, right? And it's essentially a protection order on assets, so somebody doesn't dissipate all the property that you might have some interest in. Oftentimes people do these really global things, like you're restrained from using any bank account, disposing of any vehicles, any cars, blah, blah, blah. Well, then that leaves you with nothing to spend. Or if you have a business to run, it leaves you with no bank accounts to use, right? Or you're in breach of orders. And so oftentimes people go it's usually by agreement, or people go in and have to get orders to release certain assets, allowing them to use certain assets. This is a case where these are two cases that just the court at the outset agreed that certain accounts could be available to somebody. It wouldn't be covered by the essentially freezing order, as we call it, or the restraining order on the assets. So if you ever have a case where you're trying to free up certain assets, these are two cases you can rely on for your clients that are recent. Master Elwood and Madam Justice Iyer.